Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in this video, we're going to talk about the debt that's being released on the market. There's a couple of portfolios that are being released. And then we're also going to talk about, I'm going to answer some YouTube questions. And then I'm going to leave you with a little bit of education and motivation on the way that you need to be thinking because there's you would think that we're living in two different worlds where people can view one of my videos and actually use the process and get one result, and then other people use it and get another result, and then other people see the video and think that the video didn't tell them anything. So that means that number one, a lot of people are bringing in their baggage, so to speak, or their thinking processes into what they're seeing, and that makes you see it a certain way. You're taking in the information that I give you and you're formulating it into what you can accept based on your level of acceptance. On it could be on success, it could be on on your tolerance. And when I say tolerance, that means that some people are afraid to face their fears, and people write comments right here on YouTube saying thank you because it helped me face the fear of something that they had to go through. So first, let's just go through the debt that's being released on the market, and we have a portfolio of $3.1 million, 2,500 accounts, 1,200 available. I mean, 1,200 was the average balance. Charge off date was 2010, which we all know that that's past statute of limitations for most states other than one state. And a couple of states have a 10-year statute of limitations. So if it's not March of 2010, then you could still be within the statute of limitations if you live in one of those states. Now, to find the statute of limitations, go to my website, thecreditrepairshop.com, go to my blog, type in statute of limitations, and you will see a list of the statute of limitations. And this was from a rent-to-own company, $3.1 million. This would fall into the category of, I would say, it could potentially be as a contract because it was secured by the furniture. So with this rent to own, so it was secured by the furniture. So it would be in column number 2. If it's a credit card account, it would be in column number 4. But now, something just came to my mind with the rent to own places. There was actual news reports that had showed where people were arrested when they owed the rent to own companies and they would not give back the TV or the furniture or whatever. They wanted to get that stuff back. They were actually putting arrest warrants out for these people. I'll try to find that article so you can see that. That is true. Like I couldn't even believe it when I saw it. The ACLU wrote an article about it, and they were fighting for these people, saying, this is still civil. You should not be putting people out for arrest. But what they did is they used a little loophole in the law by saying that the property is owned by the rent-to-own company, and that if they went to go get it, they could consider it stolen because the payment obligation was not made. But just think, credit card companies cannot do that. They cannot put a warrant out for your arrest for the items that you purchase using a credit card. But the loophole that the rent-to-own companies was able to use is that they actually own the property because it's rent to own. You do not actually own it. So that was a loophole in the law, and they had started putting warrants out for people to get arrested. So this debt is from one of the rent-to-own companies, $3.1 million, 2,565 in accounts. Average charge-off date was 3/12 of 2010. Average balance was $1,235. I'm going to tell you what to do about that in a moment. Let me go to the next portfolio. $4.9 million. This is unsecured credit card debt. Major banks, 4.1 $4.9 million, 7,700 accounts. Average charge-off date was 2007. Average balance was $637. Okay, so step number one, the first thing you want to do is you want to check the statute of limitations for your state to make sure that this debt cannot be collected. If you lived in another state when you accumulated that debt, you should check that state statute of limitations also. If it is past the legal statute of limitations for them to collect, and this is not where you're just running from the debt, this is something legal that you can use, that companies and corporations use all the time for their financial situation. This is a legal statute that's in the consumer's favor. If it is past the legal statute of limitations for them to collect, you have no legal obligation to pay. Watch out for them sending you letters or calling you saying that you have a moral obligation to pay. Watch out for them using words like time barred. I'm notifying you that this is a time barred debt that we are attempting to collect from you. Time barred is just another way of saying statute of limitations, debt that you don't have to pay. So watch out for those words. They had that word put into the Fair Debt Collection Practices Act to confuse you so you would not know what time barred mean. If someone called you up on the phone and said, this is so and so debt collector, and we want to ask you about how you're going to pay this time barred debt with this credit card that you had, you would not know. You would just only hear the words of the debt that credit card debt that you owe. You would not even, it would probably just go one ear and out the other ear when they said the word time barred. They have to legally tell you that it's time barred. They cannot call you and say, this is a debt that you don't have to pay, but we want you to pay it. They cannot even call you and not use the word time barred. They have to use that word because they're notifying you. They don't have to notify you what time barred mean. If you were to actually ask them what time barred mean, they would probably just hang up the phone because then they would have to tell you the truth that you don't have to legally pay the debt. So you want to, number one, check if it's time barred, past statute of limitations. If it's past statute of limitations, all you have to do is simply send them a letter stating that that they're attempting to collect a debt that's past the statute of limitations. I give you that free letter below. You don't have to talk about the debt. You don't have to talk about the original creditor. You don't have to talk about anything as long as you know that it's past the legal statute of limitations. How do you find that out? You need to look at your credit reports and look at the charge off date. As long as it's not a judgment, that's all that matters. If it's a judgment, that's a whole nother set of circumstances. But if it's just charged off, you go from the date that it was charged off. That's when the clock started ticking. And if they didn't contact you, you didn't make any payments, that it didn't reset the clock, that means that it is past the legal statute of limitations to collect. So don't get tricked into paying a penny. If you pay 1 penny, it will start the statute of limitations process over again. Now, if it's not past the legal statute of limitations to collect, the next thing you need to do is to challenge every aspect about them even coming after you for it. And this is where you make them state that an attorney reviewed it to make sure that it's true, that everything about the debt was true, and do a full debt validation, which is your uh, legal. You have a legal right to do that according to the Fair Debt Collection Practices Act. That you can validate any debt that anyone is trying to come after you for, and make them send you all the documentation to prove every aspect of it. When you do that, this is something that they don't expect the ordinary individual to do. And so when you do that, it kind of puts them back on their heels and it makes them really evaluate if they're going to try to come after you for the debt. They really like going after people who don't do nothing, the lazy people who won't even send a letter, even trying to fight for their rights. They want to really go after those people. So if you simply send them a debt validation letter, ask them if an attorney reviewed the whole thing, because you'll notice on that letter, when you get that 30-day letter in the mail trying to collect on a debt, it will say at the bottom, you have a right to dispute all or any portion of that debt. And it also states in a little line that people don't even pay attention to, that an attorney has not reviewed this. Reason why they have to say that is because if they choose to move this forward to court, an attorney is going to have to review and look at the documents. They're going to have to build a case against you, and they usually just try to do it with statements and stuff like that. But there's a whole bunch of things that they have to prove, which will make them usually dismiss them if you challenge it the right way. Now, I'm not talking about if you're dealing directly with an original creditor. This is where debt collectors buy the debt, what we're talking about. Now, you might be saying, Steve, what do I need to say in there? If I was to tell you what you need to say in there, you would be sitting there writing all day with the video. I give you those free letters. All you have to do is go below this video. The link is below here. Click that link. I'm going to give you 3 letters that you can use to fight for your rights against debt collectors. Number 1 is the statute of limitations letter. If it's past statute of limitations, I give you the letter to use. All you have to do is fill in your information. Letter number two is the cease and desist collection activities letter. This is the one that I was telling you about, where it's going to make an attorney have to state that they've reviewed everything about it, and then it's going to do a full debt validation and some other things that we put in there that they're going to have to get. And then the third one is a debt validation letter, where you can use that because it's going to be potentially some back and forth with the debt collector. So those links are below this video. So now let's get into answering some questions that we have here on YouTube. One of them is where a person said, they just said a thank you. They said, thank you. I went to court as you suggested, and a case got dismissed. Thank you for helping me grow up here. And I want to say to that individual, congratulations for standing up for your rights and just going to court, win or lose. Win or lose. Some people, you can't win unless you put yourself in the position of losing. And I want to congratulate this person for watching the video and then just went to court, and they ended up getting the case dismissed. And that brings up what I was talking about earlier too, where people are watching my videos and they are using the information in it, and one group of people get an excellent result, another group of people don't get a good result, and then another group of people watch the video and they ask me, well, what do I need to do? And I'm like, I told you in the video what to do. And the reason why people are having these problems is because you're coming into it with your own solution. You're watching my video, but you're not really watching it and you're not really listening. You're just, I don't know, glaring at it because you already have in your mind what you're going to try to do. What I want you to do is you need to erase. You need to erase all preconceived notions, and you need to just listen to what I tell you to do on the video. Because if you listen to it, and the first time you listen to it, you're going to hear one thing. Go back through, listen to it again. Listen to it again, and you're going to hear something different. And then listen to it again, and you're going to probably hear the solution, because you're going to get out of your mind the preconceived notion that you have in your mind. Because number one, if you're watching my video, you have the issue. And number one, if you're watching my video, whatever you were thinking about before is not either working or you don't think it's going to work. So you need to erase that out of your mind. And then you need to just watch the video. So we have another one here. I just got a letter to show up to court 3 days ago from now. And this person wrote this last night. And no letter warning or anything. And it was from LVNV Funding. What do I need to do? Number one, they had to send you a letter. You may have disregarded it. Maybe they sent it to a previous address, something. They're going to probably have something in court. So what you need to do, from what you told me, is go to court. You need to ask them, number one, you were not given the initial letter, but this is going to be your problem. You got the letter to show up to court. So how did they have the address to send you the letter to go to court? And I'm pretty sure they're going to probably show, maybe they won't, the letter that they sent you previous to that. But let's just go with where you're at right now. You need to go to court. You need to ask for more time. Say that you did not receive the other letter. Something could have happened. It got lost in the mail, whatever. You need to stand your ground on that. Ask for more time. You need to ask for more time to review everything. And then you're going to need to respond to that court summons. Line by line, they got allegation number 1, 2, 3, whatever they got. LVNV funding, they usually will do like 7 to 10 different allegations on their summons complaint. You need to respond to all of them, and you need to respond to them with asking number one. And I'm just summarizing. There's way more to this, and I put a link on there for you. And for anyone else that want to see it, there's a link below here on how to respond to a court summons or a service that we provide. But just to summarize, you need to, number one, ask for full debt validation, ask for full redaction of the account number, ask for a document showing how they were able to view your personal information signed by you that allowed it to be shared with LVNV funding. You need to ask for a full accounting of how they came up with the amount that they're claiming in their claim, not just bank statements. You want to unredact the account numbers on the bank statements. You want the charges, individual charges, to add up to the claimed amount with your signature or digital signature authorizing all those charges. This is something that they would have to maintain as the original creditor, and now that they purchased the debt, it is their burden to have all that information. If they don't have all of that information, one or two things can happen. They might, when you do your response and you ask for all that, they might just say they want to dismiss it. Uh, and don't let them trick you by having that affidavit saying that they purchased the debt. The affidavit does not specifically state that they purchased your account number. It does not show your account number. It just shows that they bought a pool. A pool could be anything. Well, we can throw they can say any account number is in that pool. They have to show you all of that information. So don't fall for that. All right, let's go to the next one here. Uh, these creditors don't care about your financial situation. They want the money to make a profit, and they will get nasty. Don't apply to their, I guess they're saying, demands. They don't care about your financial situation, but they do have a criteria on what they have to follow because they don't want to throw money that they're not going to get throw money after money that they're not going to get. So if you do let them know about your financial situation, they will either delay, or if you're exempt from being uh, garnished, because really what they're trying to do is see if there's some type of way that they can get you into a garnishment procedure. And if they believe that they will not be able to do it, they will probably just continue calling you and not proceed with taking you to court. They'll just, try to hammer you with calls, and then you can say you don't want them to call you anymore because that is your right according to the Fair Debt Collection Practices Act. You can tell them that you don't want them to call, and you want all communications to be sent to you in writing. Now, if you're on Social Security, disabled, unemployment, unemployed for a long period of time due to medical, uh, in retirement account, there was another one. But there are certain situations you can't be garnished, and then there are certain states that don't even allow these types of garnishments to happen. So you need to look at your state laws on garnishment, and if you don't even make over a certain amount of income, like in my state of Wisconsin, if you don't make over a certain amount of income, no matter what, they cannot garnish your wages. Next one here is one time the bank send a credit card to the IRS that I owe the company. Can they do that? What they're doing is they're not saying that you owe the company. They're sending a statement to the IRS. It's called a 1099-C, debt cancellation, where they said they're not going to be able to collect this money from you, and they want to get a full write-off on this, and they want it to be considered as income to you. You can do the write-off on your taxes, but they're going to consider that as income to you. And once they do that, they cannot sell the debt to someone. They cannot do anything once they send that to the IRS. It is done and over with, but you will be responsible for paying taxes on the additional income. So whatever they put on that 1099-C as canceled debt will be thrown on top as your income, and you could or you may not have to pay anything on that. Get with your tax professional and ask for them to look at doing a waiver on the 1099-C. Let's see here. Another one. Someone said that they have a tricky question. They misplaced the original letter from the third-party debt collector, called several times, another request from the third-party collector. I was lied to over the phone and never received a request copy from them. I received a summons, go to court November 2nd. I bought 2 separate packages from someone such as yourself to help with that situation. I'm frustrated to the point. I don't have the original letter in the possession. Okay. So because you don't have the original letter, you're past that situation. What you need to go to now is you need to respond to the court summons. That's where you're at right now. You have to go to court November 2nd. So respond to the court summons. And I just told you earlier what to do with the response to the summons. If you can go back through the video, I talked about that earlier on what you need to ask them for, so you can properly respond to it. And we do have that link below this video here too, if you need help with that. All right, so I'm going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. That's where I show you with the whiteboard my 8-point validation process. That's the way that we do it. If you cannot work with us that way, we ask that you go and work with another company, because that's the way that we do credit repair here. And we also have a settlement phase that we go through to be able to get you from A to Z with credit repair. It is a process. It's not done overnight. So don't come to us expecting overnight success. It's not going to happen. The next thing is if you don't have all 3 credit reports and scores, go to the website your3scores.com. This is like if you go to buy a car, you got to put gas in it. If you go to get your credit repaired, this is something that is needed to repair your credit. We need to know where you're at, where you stand with all 3. The free accounts and all that stuff doesn't work. Getting it from just one bureau doesn't work. There's 3 bureaus. So go to the website your3scores.com so you can know what's on all 3. Even the furniture information. This is stuff that the free reporting agencies do not give you. The furniture information is very important when you're going to be fighting against third-party debt collectors. And you need to know in the comments the exact charge-off date. The free companies don't give you all that information. So go to your3scores.com to grab those reports. And we can use those if you decide to work with us. And then if you need the court summons response, that link is below here. If you need my 3 letters, the cease and desist collection activities letter, the statute of limitations letter, or the debt validation letter, the links are below this video here. Thank you for your time. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.